Okay, we can bring Mr. Bradley into the courtroom.
Yes, ma'am. Your Honor, remember that
Can you wait till Mr. Bradley gets in here?
I just was going to ask to have a few minutes with you after before they leave.
Okay, that would be fine. We'll make sure he stays up here and that you'll have an opportunity to talk with him.
Thank you.
Okay. Okay, we can go ahead and, it's my understanding that the jury has a verdict, so we'll bring them into the courtroom.
All rise for the jury.
Please be seated. Juror number 108, are you the foreperson?
Yes.
And juror number 108, has the jury reached an advisory sentence?
Yes.
Can you please hand the recommendation form to the court deputy? Okay, Mr. Bradley, if you'll please stand to receive the recommendation. Madam Clerk, if you'll please publish the recommendation.
In the Circuit Court of the 18th Judicial Circuit in and for Brevard County, Florida, case number 05-2012 CF 35337A, in the state of Florida versus Brandon Lee Bradley. We, the jury, find the following. The advisory sentence. A majority of the jury, by a vote of 10-2, advise and recommend to the court that it impose the death penalty upon Brandon Lee Bradley. So say we all in Viera, Brevard County, Florida, this 8th day of April, 2014, signed by the foreperson, juror number 108.
Okay, please be seated. Okay, does counsel for either party wish to have the jury polled?
Yes, Your Honor.
Okay, ladies and gentlemen of the jury, we are now going to ask each of you individually concerning the advisory sentence. It is not necessary that you state how you personally voted or how any other person voted, but only if the advisory sentence or recommendation as read was correctly stated. If it is, you need only answer yes. If it is not, of course you should answer no. Madam Clerk, please poll the jury.
Juror number 147, is this the jury's recommendation?
Yes.
Juror number 125, is this the jury's recommendation?
Yes.
Juror number 156, is this the jury's recommendation?
Yes.
Juror number 1, is this the jury's recommendation?
Yes.
Juror number 5, is this the jury's recommendation?
Yes.
Juror number 65, is this the jury's recommendation?
Yes.
Juror number 87, is this the jury's recommendation?
Yes.
Juror number 102, is this the jury's recommendation?
Yes.
Juror number 114, is this the jury's recommendation?
Yes.
Juror number 124, is this the jury's recommendation?
Yes.
Juror number 108, is this the jury's recommendation?
Yes.
And juror number 107, is this the jury's recommendation?
Yes.
Okay, ladies and gentlemen, ladies and gentlemen of the jury, on behalf of the parties, the lawyers, the people of the state of Florida, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Once again, on behalf of the state of Florida, the citizens of this county, the parties in this case, the attorneys, and myself, I thank you for your service in this case. For our legal system to work, it is essential that citizens such as you be willing to sacrifice their time and perform the services you have just rendered. I hope you do not find this duty to be burdensome or unpleasant, and that you will be willing to serve again if the call comes. Now, at this time, I am going to release you. I ask that you return to the deliberation room, and I will meet with you in just a few moments. Again, thank you, and you may go with the court deputy.
All rise.
Okay, please be seated. I want to talk to the parties about scheduling. Okay, we need to schedule a Spencer hearing. How long do you need in order to prepare for the Spencer hearing?
We don't need that long to prepare for the Spencer hearing. From the state standpoint, I think we'll just have a few survivors speak to the court, family members, and that'll be the extent of the
Okay, so how long do you think the state side will take?
I wouldn't think anything more than a half hour, 45 minutes max.
Okay, and on behalf of the defense, how much time do you think you'll need to prepare, and how long do you think it will take?
Judge, I haven't talked to Mr. Lanning about it. Obviously, Mr. Lanning and I did the Spencer hearing. Just thoughts in my head the last couple of hours. We made a request Spencer hearing about an hour to 2 hours worth. Safety starting. In terms of how long we need to get ready, I know Mr. Lanning's got a capital trial coming up. That. That trial begins on May 19th.
When does it start?
May 19th.
It starts May 19th. I thought I heard you say it ends on May 19th.
It starts May 19th and expected to 11th.
I mean, I could set the Spencer hearing for one afternoon starting at 1:30, and we could just go till the end of the day. Then I need to set a sentencing. I mean, with all due respect, I was going to set the Spencer hearing in approximately a week and the sentencing in approximately 3 weeks. But if
Judge,
you...
I can tell you a week's not going to be enough. Again, Mr. Lanning and I can just sit down with some of the ideas I had. within more than a week.
Okay, that's why I'm trying to get some idea. I mean, with all due respect, you know, the schedule gets busy. I'd just soon put these dates on the calendar right now.
And because of the other case, I would ask that the dispenser hearing be held after that other prompt.
I have a different schedule starting July 1st. I was hoping to get this concluded by July 1st. So I could do it in, we could do, let me look. May 19th. That puts you May 19th, the week of May 19th, the 26th. So it looks like you'd be available the month of June, which might work out fine. Well, how about if we do this? Will you need much time between the Spencer hearing and the sentencing?
Will they working on memorandum and time? So I would intend to submit.
How about setting the Spencer hearing for June the 13th? I mean, all due respect, that's a Friday, but that works out better for my trial schedule. At 1:30? June the 13th at 1:30? And that's for the Spencer hearing? And then set the sentencing for June the 27th? And I'll set that at 1:30 as well? Does that work? The state okay with that?
Yes, Your Honor.
Okay, do you want me to order a pre-sentence investigation?
No.
It may be required. I think it's required on one of the other counts. Is it required on the robbery count?
Well, I think they can waive it. So where she would have to be.
Pardon me?
Of course you would have to prepare PSI to be working.
Okay, so we're waiving a pre-sentence investigation.
Yes.
Okay,
We would ask the defendant to cover that.
okay, Mr. Bradley, do you agree with your defense in waiving a pre-sentence investigation?
Yeah, I'll wait.
Okay, thank you. Okay, I am going to, for purposes of the sentencing, solicit memorandums from the state and from the defense, require each party to identify and argue what aggravating and mitigating circumstances were established, and to rebut the opposing party's argument, and what weight should be given to each of the established circumstances. Now, I want those before the sentencing, so can I have those? If we do the Spencer hearing on the 13th,
I would think by the Spencer hearing that should
But not by the 22nd, 20th?
with all due respect, I might need a little bit more time for that for my sentencing order.
Right, but Judge, additional information may come up with the Spencer hearing.
That's why I'm okay to do it after the Spencer hearing.
I don't have a problem if, after the Spencer hearing, if they were to file an addendum or additional report, but I think they need to get to the court enough time for the court to review, which will have your order.
Can I ask you, let's do that, if the Spencer hearing's on the 13th, can you get me the memorandums by the 18th?
Yeah.
So you should have them mostly done, and then you can add in whatever additional. So I assume you're going to know what evidence you're going to have at the Spencer hearing. So we'll do the memorandums. by June 18th. Okay, just to recap, the Spencer hearing,
Is there a time?
do it by 5 p.m.
Can I ask a question?
Yes?
Is the court going to order a transcript today? It's beneficial to us in preparing our sentencing memorandum, and we can obviously say to the court the pages on the record. One has to ultimately be done, so.
If I order that, do I have to put how soon that gets done?
Well, we're talking June, so I don't think it would have to be rushed, but I think they'll do it in their ordinary course of business, I think.
I mean, what I'm concerned is I don't want to be responsible for expedited costs.
Yeah. If they have it finished within a month, we're talking getting it in early May. So that still leaves us well over a month.
Okay, I'll order the transcript of the guilt phase and the penalty phase of the trial. And I'll order of everything regarding the trial, just so there's no misunderstanding. How about May the 23rd? Expect it by May the 23rd? Is that enough time?
Yes.
Okay, anything else on behalf of the state?
No, you haven't.
Anything else on behalf of the defense?
Judge, Mr. Robbins requested that he be housed at the Bar County Detention Center. It's easier for his family to well, yeah. And William needs to meet with the mom to the fire department hearing. I mean, he has multiple times. He wants to meet with the Bar County.
So if they come up during our live